Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the final Lawcast in a series detailing testing the waters when conducting an offering using Form S-1. The opportunities for a smaller reporting company to engage in marketing, testing the waters, and other pre-effective communications related to a public offering are limited. A smaller reporting company is defined as one that, among other things, has a public float of less than $75 million in common equity, or if unable to calculate the public float, has less than $50 million in annual revenues. The SEC has proposed amending this definition to raise the public float threshold to $250 million, but that change is not final as of yet. Separate from a smaller reporting company, an emerging growth company is one with total annual gross revenues of less than $1 billion during its most recently completed fiscal year, and that first sells equity in a registered offering after December 8, 2011. At times, a company will qualify as both a smaller reporting company and an emerging growth company, but certainly not always. A smaller reporting company is, by definition, a company subject to the reporting requirements of the Securities Exchange Act. Companies that are subject to the Exchange Act do not qualify to use Regulation A or A+. Accordingly, a smaller reporting company cannot avail itself of the broad, allowable pre-offering test the waters communications allowed in a Regulation A or A+ public offering. I do note that some smaller companies voluntarily report to the SEC. That is, they voluntarily file reports with the SEC and are not actually subject to the Exchange Act reporting requirements. These companies can complete a Regulation A or A+ public offering. Where a smaller reporting company is not also an emerging growth company, it cannot engage in Section 105C Test the Waters communications made available under the Jobs Act. This is clearly a legislative miss. The Jobs Act is intended to create capital-raising opportunities for small companies. Although I understand that the thought was to assist emerging growth companies in the IPO process, the fact is that many smaller reporting companies engage in a series of follow-on public offerings before reaching a size and level of maturity where they no longer need the assistance of rules and laws designed to encourage capital investments in smaller companies. Ironically, by that point, these companies will be able to engage in additional communications only available to eligible larger issuers, such as free writing prospectus. That leaves a smaller reporting company with only using the actual filed registration statement, Rules 134 and 135 for written communications, and live roadshows to market initial and follow-on public offerings before effectiveness of the registration statement. Smaller reporting companies are often better off engaging in Rule 506C advertised private offerings than a registered public offering from a marketing perspective. This likely unintended consequence seems a dichotomy to the SEC objective of preferring registration and its accompanying complete disclosure in the issuance of securities. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.